Okay, we saved the best for last.
Okay, folks,
Restructuring the NLRB. This group has cracked the code. Is going to share that with you today. So I don't think we really need to go into a lot of elaborate introductions here. Professor S. Stryker, our fearless leader and gracious host. Roger King has already been introduced earlier today. Senior Counsel for HR Policy Association, Mr. Sherwin, David Sherwin, Professor of Hospitality Human Resources and a law professor at Cornell University's School of Hotel Administration. And our commentator today is Jay Chun with Friedman and Asbach, representing labor unions in all areas of their operations, including collective bargaining, organizing, internal governments, and strategy. And so with that,
Shannon, I think I start
Sam, take it away.
to make the positive case for what we're saying here. By the way, we think that this proposal is going to be very attractive to a lot of people in this room if Humphrey's executive comes out a certain way. I'm certain of that. Right now, we're all betting that it will come out the other, many of you are betting it will come out the other way, but the Supreme Court has laid a lot of seeds suggesting that they are going to apply the unitary executive theory, I don't know for sure, to the NLRB and the Merit Systems Protection Board. I don't think they should, but they are, that seems to be the hints I'm getting. Chief Justice Roberts, I think, wrote this SELA opinion. The SELA opinion says that multi-member agencies are a little different. This was the Elizabeth Warren creation. We can all thank Elizabeth Warren for this, creating a single head executive agency that can only be removable for cause. And that was the case called SELA law. And the court said, and I think Justice Roberts wrote the decision, there are two exceptions. One of them is for a multi-member agency unless, this is the part that bothers me, unless it exercises significant executive authority. And now we have the per curiam connected with the Wilcox case, where I think the court said, in all likelihood, both the Merit System Protection Board and the NLRB exercise significant executive authority. There are two reasons why we're proposing this to you. One, we think it's actually undesirable for the board to be engaging in flip-flop. We agree that 80%, 85% of the cases are fact-specific. They get summarily affirmed by the Court of Appeals, but where the rubber hits the road is with respect to these policy cases. And very often, the board is changing its mind for no other reason than there's a change in the administration. It'd be one thing, there were change in the organic reality of the United States. That would be a reason to change precedent, but they just changed it because I've been writing about this for a long time. One reason I am opposed to policy oscillation, which is my term, which I've not been fully compensated, is because it makes the teaching of labor law harder. I have to constantly revise my case book to bring in and now I'm basically just referring back to the earlier cases. This is what the Trump board is doing. Well, look back at Obama 2 and 3. It just makes my job harder with those cross references. That's a joke. We think it's bad for the administration of the act because we think it encourages some degree of non-compliance. A client comes to you and says, well, why should I obey this order on email access or whatever? The board might change its mind. And it really undermines the ability to offer the kind of compliance you want to, so that only in the most difficult cases are you resisting the NLRB. So I think it's a problem from that standpoint, from the problem of certainty, planning, and by the way, the respect with which the board is held. I assure you, I teach appellate judges seminars, been doing it for over 20 years. I know how these appellate judges think, even if they're Democrats, even if they were appointed by Democratic presidents. They do not hold the board in any particular regard because it appears to be a political agency, even though it's an independent agency. So one reason is we think we want to inhibit to some extent the flip-flopping because we think it's bad for the administration of the act. The second reason is because the NLRB is on the ropes, folks. It's on the ropes. And we suggest that there is a theory. I don't know if it's going to win, but I think it's a respectable theory. It's true that Dick, I don't know if Dick is here, but bringing back the original history of the president's removal power, I think a lot of water has gone under the bridge at this point. That's why I brought up SELA law and the fact that Chief Justice Roberts wrote it. Our only hope, by the way, is that Roberts, Kavanaugh, and Barrett might save the NLRB, but I don't know if they will, because there's something to be said for the notion that if the president is responsible for the faithful execution of the laws, he should be able to remove people that make major policy. I mean, there's something to that. There's something to that. Otherwise, we have a situation as we had in New York City. You don't like the way the schools are run? Well, it's not the mayor's fault. It's the Board of Education that was set up, the regents that was brought up. You don't like the way the subways are run? It's not the mayor's fault. It's not the governor's fault. It's the MTA. There's a problem with the diffusion of responsibility in that way. On the other hand, we think that Congress has authority when it's creating an agency that was not an agency at common law, creating its own brand new agency to delegate authority to a special agency that's supposed to capture expertise, but it's certainly going to capture experience where there's some degree of stability in the law. And we think there was something you said for the multi-member agency. It is interesting that when Humphrey's executor was decided, which I think was in 1934, I may have the date wrong, 2 years before the National Labor Relations Act, maybe 3 years before it, it got a unanimous vote of the court, and it got Justice Sutherland. Justice Sutherland was the head of the, I forgot what they call this court, but the age branch, I forgot what it was called, but Justice Sutherland wrote the decision. And the problem with the decision is that it's cockamamie, in my view. It never made any sense then. Justice Jackson, in his writings as a practitioner, said, whenever you use the word quasi, because Justice Sutherland said the board is not really an executive agency, it's quasi-judicial and quasi-executive, right? Quasi-legislative and quasi-judicial. And Justice Jackson, as a lawyer, said, when you use the word quasi, you're actually putting a counterpane, which is a fancy word for a big blanket, over an unruly bed, because that's the problem with the decision. And if you look at it very hard, it doesn't hold up very well. So our theory is, it's a theory, that if the board can be converted into a purely adjudicative agency, that it stands a chance of surviving this new legal challenge. Purely adjudicative agency. And we'll talk about what that entails. One of the things that rulemaking, by the way, I believe, is a law enforcement function and should be handled by other agencies, perhaps. Even though I've been an advocate of rulemaking. But as a lawyer, I face the beast. I face the patient on the table. Rulemaking shouldn't be done by the board if, in fact, Humphrey's executor is overturned, which I think is likely or substantially diminished. Substantially, they'll say, if it has precisely the same powers as the FTC in 1934, it's okay. Well, actually, even the FTC has more powers than it had in 1934, and the board does. So we think some of those functions, we are actually helped by the fact that the general counsel is the only body that can actually do something affirmative under the statute. And that's subject to presidential removal right now. Right now. The board has some theoretical authority over our cases, but it generally delegates that to the ULP. Well, take it away from the board. It doesn't need that authority over our cases. The board has some theoretical authority over 10J. They delegate it often to the general counsel. Just take it away from the board. In other words, make it a purely adjudicative agency. There's a Supreme Court decision, written also unanimous, called Weiner versus United States, written by Justice Frankfurter. He did rely in part on Humphrey's executor. I don't walk away from that. It involved claims against the government arising out of the conduct of the World War II. And Frankfurter says, for unanimous court, it's unheard of. It's unfathomable that you can have adjudicators that can be subject to the president's removal. So turn the board into an adjudicative agency. And we think will also be properly structured. You can curb the policy oscillation. Not eliminate it entirely, but substantially curb it.
Yes, yes.
Okay, Roger.
So President Newsom is going to summarily remove a Republican board member, right, Sam? I mean,
Yeah, what's good for the goose is good for the gander. It'll happen the other way around.
where does this stop? We're trying to stop it. This purely partisan approach to what ought to be an independent agency, adjudicatory only, Sam, as you mentioned. I wish Dick were still here. I take issue with his point that, yes, only a small percentage of the board's cases have policy consequences according to his analysis. That's right to a point, but what he misses is those important policy cases ripple throughout the NLRA, NLRB jurisprudence. They are major cases. They have ramifications for labor and management many-fold beyond the case that is decided at that tip of the iceberg. What we want is an independent agency, again, where the president, irrespective of what party, can't summarily remove a board member, and a board member, she or he, decides the case on the merits. It shouldn't make a difference who's in the White House, how an 8A1, an 8A5, or a policy case comes out. That should not be the differential. So I'm going to go through quickly the specifics. Many of you I know are familiar with it. I know David has thoughts. Then our moderator I know has some thoughts also. So we propose an Article I court. If you haven't looked at the Constitution recently, there is ample precedent for Article I legislative courts. The tax court's a perfect example. Tax court judges, by the way, have 15-year tenure, and they are insulated, have been insulated from any interference as far as we can determine, looking very carefully at the jurisprudence. This new court would have 6 judges, 2 Rs, 2 Ds, and 2 independents. And defining an independent has been a challenge. We've spent a lot of time on this. I've been working on this issue now for a couple of years. I think we've come to a reasonable compromise. To be qualified as a potential independent nominee, the person could not have represented labor or management for 6 years prior to her or his nomination. They could not have appeared as an expert witness, as an amicus brief author, or in any way, shape, or form on either labor or management interests during that 6-year period. They would have to evidence by writings, teachings, lectures, etc., a propensity for independence and thoughtfulness. Now, that latter is not constitutionally enforceable, we get that, but it is instructive to a thoughtful Senate in the confirmation process. And we think the Senate does have a role here in this independent judge policy area.
Confirming the appointment.
That's right. So we have 6 judges, 2 Rs, 2 Ds, 2 Is. 3-member panels would continue, but each 3-member panel would be made up of an I, a D, and an R. We think that numerically and philosophically and ideological-wise makes sense. The Office of General Counsel would be statutorily separated from the court, but the General Counsel would continue to be a presidential nominee with advice and consent of the Senate. And we concede, although I think we could argue whether this is good policy or not, we concede the president would have absolute removal authority at any point in time for the GC. That's where the executive branch gets into the policy mix of our proposal. The new court would have a solicitor division. The solicitor would represent the court in federal court proceedings as appropriate. The new court would have an ALJ division. We think the ALJ division is very necessary and should be maintained. Appeals from an ALJ decision would be taken to the labor court on C cases, charge cases, and on R cases, appeals could be taken from regional director decisions on bargaining unit and election-related issues.
To the court.
To the new labor court. A decision of the new labor court could be appealed to any court of appeals per current procedure, so that appellate right preserves the independence of the Article I court. We could go on. Just a couple of questions before I turn it to Dave. I know some people have said, this independent definition, Roger, it's not going to work. There's not enough independence. I challenge anyone on that point.
To do better.
American Academy of Arbitrators alone has close to 600 qualified individuals. The American Arbitration Association has far more. And frankly, I think it's going to be easier to find qualified independent judges, Sam, than it is to find management attorneys that are willing to go on the board. But at any rate, these 2 new independents will have a significant bearing on the jurisprudence of the NLRA. And finally, I know the issue is, well, how do you transition to this? Whose ox is going to get gored when you transition to this? We've thought a lot about that. This would not occur until the next election cycle. The new president would have the authority, under our proposal, to nominate the 6 judges we've just described. With the advice and consent of the Senate, there will be initial 2-year staggered terms, 2, 4, and 6. That's where the policy and imprint of the White House comes in. Whoever gets nominated, obviously the president's going to carefully review those people. So we could go on. I'm happy to answer questions as we go through this proceeding, but my challenge to you is, if we don't do something like this, where do we end up? And if you've got another proposal, we'd certainly like to hear it. But if we don't do something to fix the direction in which the board is headed today, whether we have the preemption, as we discussed earlier today, flip-flopping, if you want to call it that, policy oscillation, where are we? We're back in a partisan, to the streets dispute process in this country, and that's not what we should have. David?
Roger, if I can just add one thing.
Sure.
Something we discussed previously in our meeting. We had said in our written proposal that it takes 4 members to overturn board precedent. We're changing that. The court will sit in panels of 3. Any one member in that panel can ask for full bench review. And the full bench would have to decide whether to overturn precedent.
Takes 4 to have a majority of 6. So.
4, it takes 4, so that's where the curb will be on oscillation.
Okay, so first, I'll disagree with Sam on the flip-flopping. He says it makes life harder as a faculty member. I'll argue that it makes most of us in the room somewhat relevant, so that's a positive. And then teaching in a business school, that allows me to whine all the time that while statistics don't change, the law changes all the time, so my job's harder than yours. So on those ends, I like both the flip-flopping.
Very good affirmative case.
But on the other hand, I go with a member of my board who at one of our roundtables just kind of scratched his head and said, Dan, and this is a head of labor relations for a major hotel brand, and he said, I just wish every 4 years we would go from the 40 to the 40 instead of goal line to goal line. I'm just trying to run a business and I want to know what the rules are. So that kind of is the driver when Roger and Sam and I started talking about this. And then we move in as to where the board is. And we had, and again, like Roger, I was hoping that Dick would stick around because we talked to Dick about it. And there's real question, will the board survive as it is under this court? And Dick took the position that it will. I don't think it will. And if it won't, what do we do next? Because what we have right now is basically nothing, and that's a problem. That's a problem. So now we move to the next step of what can we do to quote, fix it. And I think beating up on the board is a cottage industry from both sides of the aisle. I've got a friend who's a labor organizer. He was actually the founder of the founding leader of the AFL-CIO's Organizing Institute, and he refers to the NLRB as the No Labor Action Board. And so that's his side. And yet my management friends are sitting there saying, so wait, the investigators, the regional directors, the ALJ, the general counsel, and the NLRB who decide everything all work for the same entity. That's not fair. So both sides are whining about it, and so maybe with this being an issue before the court, there's a way to look at some of these things and try to fix them, but keep a board going, because as Roger has said and written about, without it we have chaos, and that's just untenable. So what do? So we've come up with this because it provides a lot of benefits. One thing it does, it separates out what would be the 5-member board from the rest of the agency. And that's important from both a legal standpoint and a perception standpoint. So that's a huge positive. Now, the fallback, if we don't do something like this, is you can start looking at something like the EEOC model. And the EEOC model is another thing that's just untenable for labor relations. And we can look and say, well, you know, we all know labor cases that took forever, like J.P. Stevens took like 25 years or more, I don't know if it's resolved yet. But, you know, so we could talk about how long things take before the board, but the board is incredibly efficient at the first and second rounds as compared to looking at starting litigation in federal court, where, you know, with the EEOC, you know, before you get a right to sue letter, it's at least 6 months and often longer, and then we start litigation and so on. The system is so much more efficient to get somewhere with the board, but we've got some problems.
So David, just on that point, I forgot to mention this, pardon me.
Okay.
Under our proposal, if the labor court does not issue a decision within 365 days after the case being initially docketed, any party to the case could file essentially what would be a discharge petition or a motion to have that case transferred to a court of appeals.
There's another aspect we didn't mention. The general counsel will not be enforcing the court orders. They will be enforced by either party aggrieved, the parties themselves. And the solicitor is there to defend the interests of the board, but the enforcement, because we're dealing with a legal constraint here, enforcement will be viewed as an executive function, and they're not engaged in an executive function.
So what I mean, again, putting it all back, and we're looking at other things, and we'll throw on another one. What we have right now, which is just, you know, putting aside the termination of Member Wilcox, is to look at what happened during the Obama years when it wasn't that members were fired, they just rolled off, and then we didn't have any members, then we didn't have a quorum, and once again, we had a mess. So what we've proposed in the labor court is that a judge stays in their place until there's a replacement. So
Yeah, there's precedent for the National Mediation Board and other agencies in the federal government have replacement statutes like that. So the judge stays.
the judge stays, and, you know.
And the replacement requires appointment by the president and confirmation by the Senate.
Yeah, I mean, somebody says I'm done and retires, somebody passes, okay, but you're not gonna just have a 5-year roll-off. Instead, so we won't be in a situation like we are now, where we have a board, but we don't have a board, and then all the mess that we have. So, you know, at the end of the day, what we're trying to do is keep the board alive with this new legal constraint, and while we're there, look at a bunch of the complaints that people have had, that there's some logic to them, and try to create a better situation. And I don't think it's such a horrible thought after 90 years to say, hey, wait, can we do better? What are our problems? What are some fixes? And we're not saying this is perfect, and there's obviously issues and concerns, but it can keep the board alive, and it can solve a number of the issues, whether real or just perceived, as we go forward. And that's kind of where we are on our proposal.
Jay?
So I hope I'm dead wrong, but from everything I've read so far, and I'm quite an optimist, I don't see how Humphrey's executor is not going to be overturned. Then you will have Trump stacking the NLRB with loyalists, maybe a bunch of long-standing precedents being overturned, and a whole new set of laws. But then a Democrat might be elected in the future, and the reverse will happen. And all those precedents, all those cases will be overturned, and flip-flop is extreme to another level. So this is a problem. So the labor court proposal is not only important, but I feel it's necessary. I do have a comment on it. I think Mr. King mentioned that they came to a reasonable compromise concerning the selection of judges. I think we need to go a little further there and kind of illustrate, because my point, maybe I'd like to go back to discussing the case Humphrey's executor. I thought it was issued in 1935, but that's right.
I'm not sure.
34. So
Maybe 35, I apologize.
in any event, at the time, FDR wanted to terminate Humphrey,
Right,
the commissioner of the
FTC.
FTC rather. And why? Because Humphrey was appointed by Calvin Coolidge of the Business of America's Business fame, and reappointed by even the more business-friendly Hoover. So just like Trump, he wanted to get him out for political purposes, period. And that's why you had a statute that said you can only do so if that individual is, neglectful in duty, some malfeasance in
Right,
the office and
right.
so forth. And so the question for the court at the time was, is that limitation on the president's power to remove administrative, head of the administrative agency constitutional? And of course, the answer then was yes. So we have to ask this question here, though, because today we have the same issue, essentially the same issue. You're trying to remove somebody from an administrative agency. You have essentially the same statutes, the same limitation, just cause. But then the variable here is you have President Trump has quite a different view from FDR at the time of what he thinks will make America great again. So the question is, would the justices who issued that decision, the Humphrey executive, rule the same way today, given the Wilcox case? So we can't predict that necessarily, but we can look at the justice to see, okay, well, what are some of the clues here? As a professor mentioned earlier, it was Justice George Alexander Sutherland who wrote the decision. Okay, clue number one, he was a Republican. Doesn't tell us much, he could have ruled either way. He could rule either way here, for Trump or against Trump. Clue number two, he served as Utah's representative and then senator. Utah, as we all know, one of the lowest membership in union since the 1930s to now. Still not that much of a clue, right? I mean, you can go either way. He was also what the member of the press called one of the four horsemen.
Yes, that's what I was
Conservative justices who always ruled against President FDR's New Deal proposition. And on the other side, you had the Three Musketeers, Cardozo, Brandeis, Stone, of the other thing. Still not enough clue, right? I mean, we're thinking, okay, this guy would likely maybe go with Trump, maybe go against Trump. Well, his other most famous case that he authored in the Supreme Court was a case called U.S. v. Bhagat Singh Thind, Thind. This was a fellow, a Sikh Indian fellow, who sued the government to say, hey, you know what, I should qualify to become a citizen because, under the Exclusion Act, because I qualify for the definition of an Aryan person, i.e. Aryan of the Aryan part of India. So Justice Sutherland said, let me think about that for a second. Now this was quite an impressive fellow. He served in the army in World War I. He was, in fact, for trivia purposes, the first person to be able to wear a turban in the military for religious purposes. He also got his PhD in theology and English literature from Berkeley. So he was quite an accomplished fellow. But Sutherland looked at him and said, okay, and in his decision he wrote, no, you don't fit the common sense definition of white. Okay, so you get these clues about this Justice Sutherland. How will he vote? We don't know. So that's where my comment comes from, to their proposal, which is, well, it's good that you're looking back 6 years to see if they, bent one way or the other, but I think the real thing you have to put in there in this law, maybe for all judges, especially for where it's a political hotbed, is during their tenure, they should be summarily discharged if they engage in some of these things, like taking bribes, obviously, maybe a ticket to theater, a free plane ride. I hate to say, but anything that the opposing side may accuse them of, anything that maybe Clarence Thomas might be accused of doing. If you have any of these factors, at least for your tenure, and I propose a 12-year tenure so they can survive at least one presidency, why not be immediately discharged during that time? if you have a set of quantifiable factors, quantifiable things, not just abstract language like neglect of duty or malfeasance, but if you take a bribe, if you take a loan for your son or then you're out. You're out. That's the sacrifice a judge, a neutral, must make during his or her tenure. And that's my only comment to the proposal.
Jay, I think we would echo that, and by the way, increased tenure. Tax court judges serve 15 years. And the other Article I courts have somewhat similar length, so we certainly would be open to that. The reason we didn't go the Article III route, lifetime appointments just doesn't fit what we're talking about. We don't think that's politically feasible at any rate. But I think everything
Also,
you
the
suggest
cost,
is
the
a
cost
good
point,
idea.
we agree with it as well. You said a narrow definition of cause, am I getting that right?
Right.
I think that's also congenial to our views.
Yeah, I don't think we have any problem with that. I want to throw in one other thing. I mean, we're taking the position that the three of us, maybe the four of us, that there is a lot of flip-flopping and it is problematic. I don't think Dick was as strong that way, but I'll quote a conversation between two former board members and where I was there, where Harry Johnson was complaining that as one of the two Republicans on a 5-member board, that everything he wrote was a dissent. And Wilma Liebman said to him as Harry was bumming out about it, don't worry, there'll be a Democrat soon and everything you wrote will become a majority. And that's what happened. And you could see the exact language that he had in his dissents that became majority opinions during the Biden board. And if we have a Trump board, we know that we'll see that back. So I think it's a really tough argument to say that there isn't a bunch of major policy changes going back and forth every 4 or 8 years.
So Sam, could you comment about 10J, how we would handle 10J?
Well, 10J, I think the statute has to be rewritten or clarified. 10J should be viewed as not an extraordinary remedy, but a necessary remedy. The general counsel will be seeking the 10J, right? Is there an appeal? I don't think it's appeal to the court. No appeal to the court. It's an executive function. The statute has to make clear the interim reinstatement is the expected remedy. The expected remedy, because that's the only thing that's going to work to make sure that the election will be fair. And I think we also need to make clear that we don't probe whether we probe whether there's irreparable harm, yes, but we don't challenge the determination of the general counsel in a discharge case that the discharge has had a chilling effect.
So, and let me just add to that. The general counsel can seek 10J as appropriate, but would first have to go before ALJ.
They would first have to go to ALJ for this short hearing. The problem is you can't seek an injunction which will secure the interim reinstatement of someone unless you've got something beyond a self-serving affidavit and you have some sort of contest. And I think this is something that's been suggested to me a long, long time ago by Regional Director Silberman. I got his first name for a moment. He was the Regional Director in Dan Silberman. You should have a short hearing. It could be a 2-day hearing, expedited hearing before the ALJ of the court. And the ALJ would have to agree with you. There's a need for the injunction.
So,
But that would be the extent of the court's involvement.
and to the extent that the ALJ agreed with the request, the district court judge didn't say it would have at least a minimal record to go on.
There'll be a record and some independent force has decided there's also a need for it. I think they'll stand a better chance. As I said to you, the case where the board lost the 10J was a case that never should have gotten the 10J. I know Dick was not here taking advantage of his absence. Never. They took over the goddamn facility and let in the press. That seems to me cause for dismissal. Disagree with that, fine, but it's not a case for interim reinstatement. So there needs to be that kind of filter.
Well, we would preserve 10J. It's an executive function, it's a prosecutorial function, it would be reserved with the general counsel. The labor court would not have authority to engage in rulemaking.
No rulemaking.
Not not a function of the labor court. I think Sam and Dave, we think that further insulates the court from challenges that we're seeing in the unitary executive here, right?
By the way, I want to point out to you a case that I studied more closely recently, a case called Freytag, 1991 Supreme Court decision, which involved a tax court. And the issue in the case was whether the chief judge of the tax court had the authority to assign responsibilities to a special ALJ that he appointed. And the question was, he's an inferior officer of the United States, supposedly, and under the Constitution, either the president alone can appoint such a person, or courts of law can appoint such a person, or a head of a department. The Supreme Court, the majority of the Supreme Court, not victims, said that a head of the department cannot, that the tax court is not a head of the department. It's not a department. The departments are for exclusive executive agencies. And moreover, said the court, the tax court exercises only a judicial function. And this is what we're relying on, Alina versus United States and Freytag. Scalia dissented, Justice Scalia dissented, it wasn't the majority, it was a dissent. 5 members of the court agreed with the tax court. Now, by the way, if you get rid of legislative courts, that means all of these cases, military court cases, tax court cases, patent cases, all go to federal court. Believe me, no one's going to want to be a federal judge after that. So I think there's going to be a counter there. On the Federal Reserve Board, I think they're going to find a way to distinguish the Federal Reserve Board. I mean, there have been a bunch of articles already on that. I think they'll find a way.
Well, we're going to give Roberts away with an Article I court, this approach. What
Give
we're
Roberts
talking-
away?
Yeah.
Give them method. A way.
A way.
Method.
Yeah.
Roberts wants to save the republic. He may make mistakes, but he wants to save the republic.
Yeah, I agree. So what we're talking about, we believe has ramifications beyond just the NLRB, whether it be the Federal Reserve Board, SEC. There's a serious issue in this country right now. I think we're at the height of a constitutional crisis. I know that maybe is overstated for some, but if we don't have a check and balance on the chief executive, whatever party she or he may be from, if we don't have the ability to carry on the laws insulated from instant political interference, we have, I think, a substantial problem in this
And you
country.
can't have an adjudicative function with any integrity if the president can pull you for political reasons.
So Roger, you are going to have a very public opportunity to talk about this proposal on Wednesday, next week. You're-
This week.
This week, that's right, okay. You're a witness at the House Education and Workforce Committee's hearing on.
We've taken some soundings with staff members on the Hill, and there's some support, and also some sound, I think you can see it from Matt Ginsburg. There's some support on the labor side as well. They're all waiting to see what happens.
He's smiling. I don't know.
Is he here, Matt here?
Yes.
He's here. Well, he didn't give us a green light, but he didn't give us a red light either. Matt, is that fair? Okay. There's a thumbs up from Matt Ginsburg.
So Shannon, the House Education and Workforce Committee is holding a hearing Wednesday morning. The title of the hearing is Rebalancing the National Relations and the LRA. So we'll comment, obviously, on what's happened over the last 4 years, but the labor court's going to certainly be part of that testimony. We've gotten reasonably thoughtful responses from the Hill. It may, like anything in Washington, take some urgent event, like the ruling in the Wilcox case, saying, but we think this event, Jay, may spark enough interest even on the Hill. We'll see.
May I ask what response you've gotten from the White House Domestic Policy Council staff on the proposal? Have they commented? Have you met with them?
Yes, and yes. I have talked to the White House about this, and Sam, we both have talked to the same key individual
The key labor guy.
who is reasonably interested. Now, whether his boss is interested or not, we shall see.
It's not in the employer's interest to not have an NLRA. And maybe we can discuss that with people in the employer group, because if you don't have an NLRA, you have indefinite recognition of picketing, you have secondary boycotts, you have cargo clauses, and you have no Taft-Hartley preemption. Now, this may sound like a a blessing to the labor movement, right, Matt? But that's what happens if you don't have an NLRA.
Okay, can we just take a few questions from the audience on this proposal? Yes, sir.
Please identify
Barrett
yourself.
Samson with the National Labor Relations Board. I was curious, under your vision of the labor court, would those orders be self-enforcing or would you still go to circuits?
Self-enforcing.
Okay. And then contempt powers?
So self-enforcing, the prevailing party would have the opportunity to go into federal district court
Get enforced.
to seek enforcement if the non-prevailing party failed to cooperate. And on 885 cases, we would do away with this absolute charade of having to take technical 885 if necessary, all gone. If you want to appeal a decision from a regional director on our case, you take it to the labor court rules, you go right into court if you're going to contest that. We want to streamline the process. Labor management spend needless time and money on these technical 885s, and it's a terrible use of board staff.
Next question.
Terry Noble, mediator office.
Former general counsel and NYU.
You mentioned independent judges, and you gave as an example the National Academy of Arbitrators, the American Arbitration Association. Isn't it true that many of those people, perhaps most, would have a party registration, and the world at large, no matter what their writings were, would not see them as independent?
You know, I'm going to jump in because when Roger and Sam and I started discussing this, I had that concern. I had sort of the opposite concern. Roger was saying we should have folks that aren't registered Democrats or Republicans, and then they wouldn't have an affiliation. And I'm going to say we're going to limit these 2 slots to people who have essentially opted out of the political process. In a lot of states, you can't vote in a primary if you're not registered. Yeah, and so to think that we would have enough folks who are either registered independents or not registered at all, that was too narrow. So we took the position, after fighting back and forth about it, to say we're going to look at folks who haven't represented employers or unions in the last 6 years and have been working as neutrals. And again,
We still have a registration.
and it's still, you're still going to Senate confirmed and so on. But yes, the neutrals can be either a registered Republican or Democrat, if not really, really narrowing the pool. But I mean, I don't think we have a monopoly on the truth, and it might be tweaked as we move forward. But that was the battle back and forth between what you just raised.
Yeah, I can see in a congressional committee, some members saying, how can you be independent if you're registered, whatever.
Right. Well, that's something that we'll talk about. I'm not opposed to it. I have not been a registered party guy 20 years until this year, because I'm living in New York City and I want to be involved in the Democratic primary.
You can't vote in New York
I
City.
understand your point, yes.
So that's an excellent point. I did a review of all the executive agencies that I could find as to
You mean
their composition.
Article 185.
Part of- No, executive agencies, Sam, in this research. And there's a very high number, I won't call the exact number, that have partisan political definitions, which has never been challenged. I couldn't find a case that had upset that partisan political
Balance.
balance, if
Balance.
you will. So I asked my friends, if you've got a really difficult policy case and you've got 2 Republican judges, 2 Democrat judges, and assuming the Democrat judges are going to have a union perspective, Republican judges a management perspective, how is that dynamic in the court going to work to influence the 2 independents? And I think that's going to be a very interesting dynamic. And you're right, some independents are going to be viewed less independent than others. That's where the president's ability to influence policy comes in. But the Senate has a role here to play. And I think long-term, the jurisprudence under the National Labor Relations Act will level out considerably to get 4 votes on the 6 court membership you're gonna have to make a reasonable case to these two independents, whoever they may be. It's certainly better than what we have now, because we can predict almost with certainty now how any given case is gonna come out. And that's just not intellectually appropriate, it's not jurisprudence appropriate, and it does neither labor or management or employees any good.
But I'll just narrow point on party registration, you're still thinking about it. Do you understand your point? Anyone else?
Any additional questions?
Comments? No one wants to be kept from the reception. Are we ready for the reception? I don't know if we're ready for it. Allison, are we ready for the reception? Allison? You hear, she hear? I don't think we're ready for it. Let's have some voting. Please join me in thanking.
Thank you.